to make you the smartest person in the room when it comes to the Second Amendment, sometimes we have to talk about other issues that touches fingers with constitutional doctrines. That's very important to understand so you understand how the right to keep and bear arms fits into the bigger, broader societal and constitutional context, which is why I want to talk for a few minutes today about what you need to be watching out for in the oral argument involving the Donald Trump presidential immunity case. Now, this involves Donald Trump, President Trump specifically, but the rules that we be set out by the Supreme Court involving presidential immunity will not just apply to President Trump, it will also apply to future presidents. So thus, we must talk about what this means for the Constitution, what to look for, and what it might mean for your Second Amendment rights. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of several Second Amendment books, including Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, so we got a big oral argument this week before the United States Supreme Court in the Jack Smith as the special prosecutor against President Donald Trump, associated with or arising from allegations that Donald Trump contributed to a quote-unquote insurrection and things along these lines on January 6, 2021, as Donald Trump was the president of the United States and was trying to win the White House as well. Now, what I want to focus on today is the issue, the constitutional questions presented in this fight between the special prosecutor, Jack Smith, who's been hired to go after Donald Trump by the Department of Justice, and President Trump as the former president for his actions while he was president. And that's key to understand, that the indictment involving January 6th involves the fact that Donald Trump was the president at that time and thus has at least some level, if not absolute, presidential immunity. Now, big picture wise, keep in mind we have three branches of government. We have Article 1 of the U.S. Constitution creates the Congress. Article 2 of the Constitution creates the executive branch or the presidency, the commander-in-chief. And Article 3 deals with the court system, one Supreme Court and inferior courts as created by Congress. This is important to understand because there's a long-standing understanding that this balance of powers, the separation of powers between Congress, the presidency, and the courts must be respected. One of the doctrines that has arisen to make sure that the Congress as well as the courts, Article 1, Article 3, respects the powers and authority of Article 2 presidents is the notion of presidential immunity, which says by and large, presidents cannot be sued or indicted or legally tortured in any respect for the decisions they make or their actions as president, because if you did not have this, they would be sued a million times every day, all the time, both during the presidency and after the presidency, for all sorts of decisions they make. Keep in mind, going back to the Iraq War, let's say, George W. Bush and Karl Rove were repeatedly called things like war criminals by those that did not like Republicans. So you can see how if you don't have some form of immunity here, the presidents would be sued all the time or indicted all the time. So with that in mind, what is going on with this President Trump case and what do you need to know? The first thing to keep in mind, to watch out for, is will the Supreme Court actually ask a critical question before they even get to presidential immunity? And the question about presidential immunity, of course, is if President Trump is immune for prosecution by Jack Smith, then that criminal indictment involving January 6th down there in Washington, D.C., in front of that obviously federal anti-Trump judge, guess what? That will go away. But before we even get to that, and this is, I would call this sort of a dark horse argument that is now being advanced, has been advanced, and is totally legitimate, but hasn't gotten nearly enough media attention that I think it should. And that is whether or not the special prosecutor, Jack Smith, actually has the legal authority to do anything with respect to Donald Trump. Keep in mind that if you want to be a presidential officer, like the Attorney General of the United States, Merrick Garland, for example, or a United States attorney for a particular district, like the United States attorney for the Southern District of New York, guess what? How do you get that job? The first thing is you have to be nominated by the President of the United States. Then, before you get the job, you have to be confirmed by the United States Senate. It's a presidential appointment. Now, Jack Smith, the special prosecutor who's basically running the Department of Justice when it comes to going after Trump, guess what? Jack Smith, the special prosecutor, was never nominated by any president to do anything. And Jack Smith, the special prosecutor, was never confirmed by the United States Senate for any reason at all. So now, arguably, and there's a very powerful amicus briefing here by several prominent scholars that say that Jack Smith is not a presidential officer. He is not allowed to do any of the things he's doing. He's basically running the Department of Justice vis-a-vis President Trump, and that is not allowed because he was never confirmed by the Senate or nominated by the presidency, and that Merrick Garland, the Attorney General of the United States, is not permitted to delegate this constitutional authority to some random guy off the street. That's simply not allowed. And keep in mind the independent counsel statute that you may recall from the days of Ken Starr, investigating Bill Clinton. That statute was on the books. That statute has long since expired. That statute has not been in the books for a long time, which means the only authority Jack Smith could possibly have is authority given to him, in theory, by Merrick Garland, the Attorney General for Joe Biden. But again, that still mandates, so the argument goes, that Merrick Garland has to make all the decisions and that the Department of Justice has to make decisions vis-a-vis Donald Trump. That has not been occurring. Jack Smith has been out there acting ultra vires, meaning without any legal authority. And the consequence of this, if the Supreme Court bought into this argument, would mean that literally all of the work, all the indictments, all of the investigations, all the grand juries, all the subpoenas, and so on and so on and so on, that Jack Smith's office issued would be null and void. They would go away, which means the lawsuits, the prosecutions down in Florida and in D.C. and so on by Jack Smith, not just against President Trump, but against anybody else, would also go away entirely because he was acting without legal authority, ultra vires. So it'd be no different than if I just went out and indicted people. I don't have the authority, so it wouldn't count. So watch very carefully to see if the Supreme Court asked about the authority of the special prosecutor, Jack Smith. But beyond that, keep in mind, on the presidential immunity question, the Supreme Court is going to be trying to draw lines between making sure that the office of the presidency is respected and is not encroached upon by Article III courts or by other people, such as the current president of the United States, Joe Biden. Bear in mind that Donald Trump is being brought before Article III federal courts right now in D.C. for his conduct as an Article II president. So the question is that allowed? Are Article III courts allowed to sit in judgment over an Article II president? And if yes, under what circumstances, when we know that generally speaking, there's a general immunity. Now, the other thing to kind of keep in mind about all this is very important is that was President Trump on January 6th acting within his scope of his authority as president? And I think there's several powerful arguments that he was. The first one, of course, is that he was the president of the United States, which makes him the chief law enforcement officer to enforce the laws. Because as you know from Schoolhouse Rock and other cartoons when you were a kid, the way it works is Congress passes the laws, the president enforces, hear what I just said, the president enforces those laws, and the courts interpret those laws. The Congress passes the laws, the president enforces the laws, the courts interpret the laws. So here you have President Trump arguably trying to enforce the federal laws, the federal election laws, which arguably is one of the most important things he does beyond protecting our borders, which this current president, Joe Biden, is not doing, but set that issue aside. President Trump, of course, had a duty under the law to effectuate and to enforce federal election laws. So certainly, conceptually, that would be well within his constitutional authority. But beyond that, there's also another important function that an Article II president has, and that is to recognize that his ability to speak out serves as sort of standing on a platform known as the bully pulpit. Now, the bully pulpit was something named by President Teddy Roosevelt in the 19th century, which is really just talking about the platform the president has to talk about political issues, national issues, and whatnot. And you could say that Donald Trump on January 6th, when he was speaking, was specifically talking about, for example, issues associated with the election, the fairness of the election. Did he think it was fair? Does not. Again, could be well within his authority. And keep in mind, there's also First Amendment issues here, which we won't need to get into, but you have a famous case from the 1960s called Brandenburg versus Ohio. Brandenburg versus Ohio, a very famous First Amendment case that says that Americans have a First Amendment right to speak literally literally to advocate the violent overthrow of the federal government. They're allowed to say that and advocate that under the First Amendment, with the exception of they're not allowed to do so if doing so would cause imminent violence or harm. So again, just to keep in mind, there is this Brandenburg precedent out there that you may have some discussion from the U.S. Supreme Court in 1969. It's a landmark First Amendment decision that remains good law to this very day. The last thing I want you to keep in mind here is that one of the questions that keeps popping up is, could the President of the United States legally have the authority to tell special forces to go out and engage in violent murders of the American public? Could he be prosecuted criminally for such a decision? Now, I think the answer is yes, he could be prosecuted, but the distinction that I'm thinking could work here. Now, there's some debate about what I'm going to say here, and I'm not sure the Supreme Court's going to go here, but I'll tell you how I conceptually think about this issue. Is I like to think carefully about the notion of malum prohibitum versus malum in se. I think it's a distinction between just laws which are malum prohibitum, laws that are simply laws because we say so. Think about the length of a barrel as to what's a short barrel rifle versus a normal lawful rifle, if you will. That is simply arbitrary. Those numbers are arbitrary, just set by a legislator. There's no moral or evil component to the length of a barrel. It's simply set by legislators. Those are malum prohibitum laws. They're just laws because we said so, basically. We say so. We're the legislature, we say. But then you have malum in se laws, which are laws that are basically speak to things that are moral or inherently evil in and of themselves. Malum in se laws are things like murder, laws against rape, laws against robbery, laws against fraud, right? These are obvious, even in an uncivilized world, barbarian world, if you will. Notions of these could even be there sort of in the human moral code. So malum in se law. So I think there could be a distinction made between process crimes like counting electoral votes, things like this, versus malum in se. So in other words, if the President of the United States engaged in malum in se crimes, violent acts, outright, he engaged in rape, murder, things like this, I think if they're malum in se crimes, that would clearly be outside of the scope of his presidential authority and could potentially be indicted and not have a presidential immunity defense. But I think malum prohibitum crimes, which are really process crimes, things like that, I'm like, I think maybe they could be protected. Now, I'm going to push back against my own argument just to let you know how to think about these things in a complicated way, a nuanced way, if you will. I might push back on my own argument and say, well, Mark, what happens if the President of the United States issues a drone strike and that drone strike that he issues winds up killing people? So isn't that equivalent to a malum in se murder crime? Or if he declares an illegal invasion of a country that kills a lot of people, isn't that murder? And if that's the case, wouldn't that be a malum in se crime? Nevertheless, don't we want the President of the United States to be protected with a notion of presidential immunity for those kinds of decisions to send men to their deaths or to kill people as part of being the role of the commander-in-chief? And I think that is a fair pushback on my distinction between malum prohibitum crimes, where you would get absolute presidential immunity, versus malum in se crimes, where maybe you would not. Now, what I think may happen here, we'll see what happens at oral argument. I think the U.S. Supreme Court is going to ask a lot of hypothetical questions, and I think the reason why they're going to do that is they're going to try to figure out where exactly is the line between presidential immunity on the one hand and something where they can be indicted. I don't think they're going to say it's absolutely complete presidential immunity for any and all things ever. Anything that they can do in office, they're allowed to do. I don't think the Supreme Court will go that far, but I think they are going to make sure that presidents are broadly protected. And as to what happens in this case, I think there's a good chance that the Supreme Court will send this case back down and remand it for further information and fact-finding, perhaps, but I think that would be a win for President Trump, because anything like that will delay the trial and will likely delay these other absurd trials involving him until after the election, which at least is a pretty big win for Donald Trump. But again, we don't need to get into those political matters right now. We're really just talking about the constitutional constitutional issues of presidential immunity and protecting the sovereignty, if you will, of Article 2 presidents against the influence or interference by Article 3 courts or Article 1 Congress. This involves really the courts, by the way, and not Congress specifically. But presidential immunity could apply against all of these people, including the bureaucracy. All right, folks, hope you learned a little bit something here today at the Four Boxes Diner. Make sure you follow me on X at Four Boxes Diner, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.